So my talk today is going to be on the Talmud Torah Etz Chaim Legal School in the 18th century Amsterdam context, which is about the private international law between the Nação, Portuguese Jewish community, and the Jews in the Ottoman Empire. Why this legal history? Marty, as I said earlier in the introduction, Marty Koskiniemi and Asaf Lichovsky speak about dealing with Eurocentrism in international law and also what is the contribution of Jewish law or Jewish legal thinking within international law. In this research, I implemented a number of methodologies, including archival research, legal anthropology, case studies analysis, and rabbinic legal analysis. A little bit about the history of the Nação, which are the Spanish Portuguese Jewish nation. Jews were expelled from Spain in 1492. A group of those Jews went to Portugal, and 5 years later, they suffered forced conversions. The Inquisition was instituted in 1536 in Portugal and lasted until 1821 in Portugal and 1834 in Spain. Throughout that time period, Jews managed to, as conversos in the Western hemisphere, they were able to establish a global network, which also spans to the east in the Indian Ocean. And as we move forward, today's talk is going to focus mainly on the Ottoman Jews, the Ottoman Sephardic Jews, and the Portuguese Jews in the Amsterdam context. A little bit about the background of this for this talk. In 1611, the Dutch began their relations with the Ottoman Empire with Cornelius Haga, who goes to Turkey. And in 1625, the Directorate began for the Levant trade, where they sent numerous of Dutch consuls in Aleppo and Izmir, so in Syria and Turkey. And in 1625, as a result of this Levant trade, Jews received consular protection. Now that we know the context of what's happening, we can understand why Jews need consular protection to be able to engage in trade. This book is one of the sources which speak about this political and legal context, Ottoman and Dutch merchants in 18th century, written by Ismail Haki Kadi. And this one as well, Intra-European Litigation in 18th century Izmir, the role of the merchant's style. The Ottoman Empire had different administrative units within the early modern context, known as Eyalet and Sanyak. In the 19th century, then they changed to what's called Vialet. In this map, we can see how these administrative units were separated and what today is known as Israel-Palestine. And we can see how the Sanyak and the Vialet correlate to each other by regions. The primary sources for my research come from various sources. Peritz Es Haim She'elot Teshuvot, which refer to the rabbinic responsa literature, which are 15 volumes of questions written by students, and some of them written by the judges of the Portuguese Jewish community. Also, we have the Portuguese Jewish communal archives, which are housed in the municipal archives of Amsterdam. Many of them are written in Portuguese. And we have also the Livro Livro de Citações e Resoluções, 1717 to 1816. And what we find in these records written in Portuguese are various business recordings between members in the community, and they make vows or oaths to engage in trustworthy business according to Jewish law, halakha. The Livraria Montesinos, which is the longest Jewish library standing to this day in Europe, is in Amsterdam, and we can find books there that go back to the 12th century. I think the oldest book is a Mishneh Torah by Maimonides. It's 12th century, and they have it there from France. As we heard in the lecture by the keynote speaker, Jews were not accepted within the European context. And this is what makes this research special. Because Jews, when they come into the Dutch context, the Dutch Republic context in the 17th century, they come by invitation. And some scholars, like Peter Emmer and Jonathan Israel, they assert that Jews were accepted within that context when no one else wanted Jews in their countries or their territories, because they had special skills in trade. And if you know a bit about the history, the early 17th century, the Dutch Republic had been engaging in the East Indies Company, and then in the Dutch West Indies companies in 1621. Because Jews and conversos had established such a network around the world, whether it was in the west coast of Africa or in the Caribbean or going all the way to India, they knew the languages, they knew how to trade, they had connections in various places. They knew how to handle different money or use of money involved in this in long distance trade. And for that matter, various cities within the Dutch Republic permitted Jews to come into their cities. They were mainly in the port cities, Amsterdam, Friesland, Middelburg. When we talk about halakha in the legal codes, Jewish law, there are four main texts or bodies of law which are very important for the Sephardic community in Amsterdam: the Talmud with its 61 volumes, the Geonim with all of that period of literature, about 600 years, the Mishneh Torah written by Moses Maimonides, and the Shulchan Aruch, which was authored by Rabbi Yosef Karo. Within the Portuguese Jewish community, there is a governing body called Ma'amad. The Ma'amad is the administrative body over the community, which has ultimate authority, even above rabbis. Rabbis are just employees within this community. And then we have the Bet Din, which is comprised of a minimum of 3 judges, 3 jurists who are scholars in the Talmud and in all of the body of law, which I just explained in the previous slide. At the Etz Chaim Seminary, students learned various topics of Jewish law, but outside of that, they were also encouraged to learn secular studies, whether it was in philosophy or even Christian history, in some cases, Latin and Greek, and learn all of the classics. This made this community very special because they were very well involved in the humanism at the time, as well with Jewish law. the Chachamim, or the rabbis, who were teaching in the 18th century, which is our context, are Ishaq Haima Ben Dana de Brito and David Cohen de Acevedo. And there are three students, which I want to focus on their responsa for the purposes of this lecture. We have Ishaq Ben Shlomo Saruco, David Ben Rafael Mendola, and Shemuel Mendez de Sola. Our first case is in 1752 in the Eyalet of Egypt, and we have the generic name of Reuben and Shimeon. And in this case, Reuben lives in Amsterdam while Shimon lives in Egypt. Reuben assigns a power of attorney to Shimeon so that he can sell all the peppers that he sends him by sea. Reuben tells him to sell everything and send back the profits. Unfortunately, the ship suffered bad weather and could not reach the destination in the allotted time for Shimeon to sell the peppers. After the passing of time for the business, Reuben claims that Shimeon did not fulfill his power of attorney. Shimeon then sends Reuben wax in return for the loss of the peppers. However, Reuben demands that Shimeon send him the peppers, even though it's not his fault that they were damaged. This question was brought forth to the judge, Ishaq Haima Bedana de Brito. This response first distinguishes between a partnership and agent. The agent does not have the same responsibility as a business partner. This is the case of force majeure. Does the agent have to pay for loss due to force majeure or not? According to the halakha, the agent does not have to pay for the loss due to force majeure. However, if the agent makes any changes to the stipulations of his or her power of attorney without permission of the principal or the grantor, it is canceled. In that case, the agent would be held responsible even if he or she had suffered force majeure due to natural causes. The verdict of this case was judged in favor of Reuben because Shimeon made changes to the terms of his power of attorney despite the loss at sea from natural causes. The fact that he sent wax, which was in his possession, he intended to enrich himself instead of returning the damaged peppers to Reuben. Therefore, he was held responsible for paying the value of all the peppers. So this is a case dealing with the concept of force majeure and power of attorney. None of these cases or none of this trade could have been made possible without the concept of the shaliach in Jewish law, which is the agent or the power of attorney. Our second case is in 1767 in the Sanjak of Acre or Akko. Again, we have the generic names Reuben and Shimeon. So this case deals with gifts, ownership, and possession in Canaanite slavery. Reuben lives in Sipori and owns a Canaanite maidservant. By Canaanite maidservant, this is a generic legal term in the Talmud for a slave, a non-Jewish slave. He bought her according to the law of the land. So that means this is the law of the land at the time, which is in the Sanjak of Acre. After a time, she expresses to her master to free her so that she could become a Jewess. Due to difficulties with this, he sends her away as a gift to a relative who lives in Tiberias. He sends her with a note stipulating that he take care of the details to free her according to the law, making her a Jewess. Reuben expresses that he has full trust in Shimon to do this on his behalf. Upon receiving the letter, the brother replies, I don't know if you heard, but one who frees his or her slaves violates a positive precept. You shall make them serve you forever. He then continues saying that the manumission of slaves does not apply at the present moment. Therefore, he desists. Reuben replies and tells him that since he does not want to violate a positive precept of the Torah, he will repeal the gift. Reuben then sold her to Levi. This is a third person involved, his beloved friend who lives in Tiberias, and gave her as a gift. Since Shimon knows the scriptures, he thought to return the slave to Reuben, but Reuben had already decided to give her to Levi instead. How was he allowed to do so, being that he had not received the gift in return? This response cites the Talmudic notion of receiving gifts. Once a gift has been endowed, even if the recipient hasn't received it, it is considered received. The giver no longer has possession of the gift. Therefore, the receiver can choose whether to receive or to return it. As such, the giver cannot change his or her mind afterwards. In the same vein, the receiver cannot change his mind until he has possession of the gift. This case was judged in favor of Reuben, since Simon never received the gift. He didn't accept the stipulation in Reuben's letter to free the slave. Therefore, the ownership was in the hands of Reuben. Accordingly, he could do so as he pleased with her. And in our third case, this is already early 19th century, 1803, in the Eyalet of Sidon between Issachar and Zebulon. This is other generic names for two Jews doing business in long distance trade. And in this case, we deal with business partnerships, power of attorney again, and investment and profits. Issachar sends merchandise to Zebulon from his city, which is Amsterdam, to Sidon in Lebanon, to sell them in his city and send him the profits. Zebulon sold the merchandise and made profits, but did not send the records of sales nor the profits to Issachar. Zebulon mistreated the money of his partner. Issachar went to Sidon and saw that Zebulon was a wealthy man, renowned by all. Everyone there knew that Zebulon had enriched himself through Issachar's investments. Now Issachar files a lawsuit against Zebulon for him to return the profits and the investments of his merchandise. What is the verdict in this case? The responsum establishes the difference between business partnerships and power of attorney to determine which is the case at hand. In a business partnership, it is prohibited for an individual to utilize any part of the principal, the investment, without knowledge of the investor. This constitutes to theft. An agent, however, has more autonomy to make financial investments. Also, in the case of a business partnership, the partner who takes actions in business is liable to giving a share in the profits to the investor. In the verdict of this case, it was judged in favor of Issachar. It was decided that since this was a business venture and that Zebulon did not do honest business with Issachar, he must pay 50% of the profit which he had gained from Issachar's investment, especially because everyone in Sidon knew that Zebulon had enriched himself with Issachar's money. So, some of the things that we learned from these analysis of these three cases is that Jews are able to engage in international trade through contractual agreements according to the halakha. When Jews did business with each other, they would stipulate through notaries in Amsterdam, they will stipulate that they are going to follow the rules according to the Shulchan Aruch. So the Shulchan Aruch becomes the international legal code for business among Jews in different lands. Halachic business law is based on trust and goodwill. So there's no power to enforce this. There's no police, so to speak, which is very similar to how international law works today. There's no police force to enforce these rulings and laws coming from the ICJ. Although jurisdiction is flexible, the Amsterdam Bet Din is presiding. So in Jewish law, just as in international law, there is a code which Jews should abide by, but there is no rule as to which Bet Din or which Jewish court can preside over a case. In fact, in some cases, even two courts can work together for a particular case. Within that context, the Jews in the Ottoman Empire who did business with Jews in Amsterdam, they gave precedence to the Amsterdam Bet Din. The reason being is because in Amsterdam, Jews, the Portuguese Jewish community was allowed to have political religious autonomy when it came to matters of business and also of religion, as long as there were no contradictions with or challenges to the local law. And political religious autonomy for Jews in Amsterdam and the Ottoman Empire allows for self-governance. This topic is, or this idea is very important because this is what the Jew is looking for. And if we read all of the literature from the rabbis speaking about the Messianic era and speaking about the political consciousness of Jews in exile, Jews are seeking self-governance. And in the literature of international law, much of it, what is written in the 19th and 20th century, is written from the perspective of sovereignty, meaning those peoples who do not have self-governance, they do not have a voice or a place at the table of international law. And so, because of this context that we heard from our keynote speaker, Jews had to then find ways to maneuver around this social, political, and legal context. And we can see how through the Shulchan Aruch and Jewish law, Jews are able then to engage in international commercial law and thereby establishing a sense of self-governance. Thank you.